On the 29th of May 2026, a court in Port Harcourt quietly erased every political decision Nyesom Wike's proxy chairman made in Rivers State over the last 18 months, every candidate, every nomination, every party structure, and the man himself told Nigerians to wait for INEC's list in July as if a verdict of that magnitude was a scheduling matter. The Court of Appeal did not merely remove a party chairman, it voided retroactively every decision made by the Tony Okocha-led APC executive in Rivers State from December 20, 2024 to the date of the ruling. Every candidate nomination, every party representation, every structure Wike spent 18 months building inside the ruling party, gone, null, void of no effect. Wike's response that this is a procedural technicality and Nigerians should wait for INEC's July publication is a delay tactic wearing the costume of patience, because by July, the window to reconstruct those structures will have closed. This story is not about a court ruling, it is about what happens when a man who built his entire political empire by using the courts suddenly finds the courts being used against him, and what he does with the one option still left, the Supreme Court. Here is the question this investigation will not answer until the end. The same Supreme Court that handed Wike his most powerful weapon in 2025, the ruling that restored the Amayuwile Assembly and gave Tinubu the legal pretext for emergency rule in Rivers State, is now the only institution that can save what remains of his 2027 architecture. Who in that court has already been in the same room as Wike, and why did the Supreme Court itself have to issue a public denial about it? In Nigeria, the judiciary does not resolve political crises. It is the arena where political crises are fought by other means. What you are about to see is not in the headlines, not because it is insignificant, but because the person at the center of it is counting on Nigerian attention moving on before the implications land. Subscribe to this channel because the next stage of this story moves faster than the news cycle, and you need to be ahead of it, not behind it. Now let us establish exactly what happened and why it matters now. Chief Tony Okocha is not a peripheral figure in this story. He is Wike's instrument, the man installed to control the APC machinery in Rivers State so that Wike, a serving minister with no formal party position, could still direct candidate selection, delegate allocation, and party structure ahead of 2027. On December 20, 2024, Justice Obomanu of the Rivers State High Court nullified the congresses that produced Okocha as chairman. Okocha's faction appealed. On May 29, 2026, the Court of Appeal in Port Harcourt upheld Obomanu's judgment. The structure is gone twice over. The surface narrative calls this an internal APC dispute, factions, congresses, legal technicalities. The buried narrative is structurally simpler. Wike holds no elected office in Rivers State. He holds no party position. Every piece of influence he exercises there flows through proxies. Remove the proxies and the influence has no legal vessel. The historical precedent for this is not obscure. In 2007, the Peter Odili machinery in Rivers State was dismantled, not through elections, but through a sequence of court orders and party restructuring that his successors used to strip control from his allies piece by piece after he left Government House. Wike used that exact playbook against Siminalayi Fubara in 2023. The courts are now running it against Wike.
And this is where the picture changes entirely. The reinstated APC faction, led by Chief Emeka Beke, whose leadership was restored by Justice Aprioku's judgment as far back as August 2024, has formally declared that every candidate produced under Okocha's tenure has no legal standing. That is not limited to Dr. Dax George Kelly, the man Wike publicly signaled as his preferred governorship successor. It extends to National Assembly candidates, State Assembly candidates, and local government representatives who carried certificates from the Okocha-led structure. The Beke faction has gone further still. It has asked the Rivers State Independent Electoral Commission to withdraw certificates of return issued to Okocha-era candidates from last year's local government elections and reissue them to Beke-aligned candidates. That is not a legal technicality. That is a retrospective erasure of Wike's political footprint at every level of Rivers State governance. And the mechanism being used is the very judicial system Wike weaponized against Fubara for 2 years. Now to the layer most analysts are not reaching, the specific legal architecture that makes Wike's position more precarious than his public posture suggests. Section 87 of the Electoral Act is the operative provision. It requires that party primaries be conducted by a validly constituted party executive. If the executive that conducted those primaries has been judicially declared invalid from inception, the candidates produced by that executive have no legitimate procedural foundation, regardless of how INEC has listed them to date. Wike's instruction to wait for the INEC list is a calculated bet that INEC's administrative inertia, combined with pressure from Abuja, will insulate the Okocha-era candidates from formal delisting before July. That bet is structurally exposed. In concrete terms, here is what Wike loses if the Beke faction's interpretation prevails. George Kelly's governorship candidacy, the National Assembly positions of allies like Kingsley Chinda, whose cross-party positioning under the Rainbow Coalition was built entirely on Okocha-era party structures, and, most critically, the credibility of the claim that he controls the Rivers APC machinery that any presidential candidate needs to court ahead of 2027. That claim is the source of his leverage over Tinubu. Strip it, and the arrangement that has held since late 2023 becomes renegotiable. The 2027 calculation is the axis everything else rotates around. Rivers State is not among Nigeria's largest states by population, but it is among the most consequential by revenue, oil money, federal allocations, and the financial ecosystem connected to both. Tinubu's re-election strategy in the South-South requires Rivers. The arrangement made in 2023, Wike delivers Rivers, Tinubu protects Wike's dominance of the state, is now under judicial stress that neither man controls. Every ruling that strips a Wike-aligned candidate from the ticket is a data point the presidency is reading in real time. Does the president still need Wike as the mechanism for Rivers, or has Wike's legal exposure made him a liability to be managed rather than an asset to be protected? The Rainbow Coalition, Wike's cross-party construction bringing together the PDP, APC, Labour Party, and Action Alliance under a single electoral front, was his redundancy mechanism against exactly this kind of legal attrition. If APC candidates are delisted, the theory is that the same political interests re-emerge under other party tickets. But that maneuver requires party structures and INEC deadlines to align, and both are now moving against him simultaneously. Two power blocs are watching this unfold without declaring their position. The first is the Ogoni constituency, a critical bloc that has historically demanded governorship rotation and has watched Wike's implied backing of George Kelly and Ikwere with visible unease. No Ogoni leader of national standing has publicly endorsed the Rainbow Coalition's emerging architecture. Their silence is not neutrality, it is optionality. They are waiting to see whether the judicial dismantling of the Okocha structure creates a space they can enter. The second is Rotimi Amaechi. He built the original APC structure in Rivers before Wike migrated into it. He has not spoken since the May 29th ruling. His silence is not neutrality either. It is a man who still has loyalists inside the structures being contested, watching to see which legal interpretation prevails before he moves.
Follow the money through the specific mechanism at stake. The Amwechi Ora APC structure controlled candidate selection for every elective position in Rivers State that the APC intended to contest in 2027. Nomination forms passed through that structure. Delegates were allocated through it. Primary supervision operated under it. Candidates who purchased those nomination forms at costs that do not occur in any public record now face the prospect that their investment carries no legal weight. The financial trail of the Rivers APC primary process is, at this moment, completely invisible to the public.
That invisibility is not accidental. One name appears across every document connected to this story, not as a party official, not as a candidate, but as the connective tissue between the structures being dismantled and the judicial institution being approached to reconstruct them. That name is Wike's, and his relationship to a specific judge whose name appeared in a public controversy in March 2025, which the Supreme Court itself had to respond to formally, is the thread we are about to pull. But first, here is what almost nobody has connected yet, and it changes the entire picture. The national implications of this story are not abstract, they are institutional, economic, and security specific. Rivers State is the second highest generator of internally generated revenue in Nigeria. Its oil infrastructure is embedded in federal allocation formulae that affect the entire Niger Delta's fiscal position. A state whose ruling party machinery is in judicial receivership, two competing executives, both claiming legitimacy, neither able to act without exposing itself to contempt proceedings, does not merely face political uncertainty, it creates a governance void that investment decisions price into their risk models. Shell's ongoing divestment from onshore assets in the Niger Delta is not disconnected from this. International oil operators assess political stability as a cost variable. An election cycle with an unresolved legal contest over the legitimacy of every candidate on the APC ticket extends the window of that instability through 2027 and into the years that follow. The security dimension is not theoretical either. Since 2023, the Rivers crisis has operated with a shadow governance layer, cult groups, militant networks, and informal enforcement actors positioning themselves as operational arms for factional interests. The bombing of the State Assembly complex, the dynamite explosion near Hotel Presidential on Aba Road, the arson attacks on LGA offices during the 2023 disputed elections, these were not spontaneous. They were the violence of formal political competition displaced into informal channels. An extended legal contest keeps that shadow layer activated. It gives those actors continued relevance to someone. Now, the name and the controversy. In February 2025, the Supreme Court handed down the judgment that became the most consequential ruling in the Rivers State crisis. Justice Emmanuel Agim authored the lead judgment, a 3-2 decision that restored Martins Amwehule as Speaker and reinstated the pro-Wike lawmakers as the legitimate Rivers State House of Assembly. That ruling gave President Tinubu the legal foundation to declare emergency rule in Rivers on March 18, 2025, suspending Fubara, his deputy, and all elected assembly members for 6 months. 1 month after that ruling, in March 2025, photographs circulated on social media of Justice Agim seated beside Wike at the University of Calabar convocation ceremony, while the Rivers political crisis remained in active judicial proceedings. The Supreme Court issued a formal public statement through its Director of Information, Dr. Festus Akande, clarifying that Justice Agim attended as an honoree, not as Wike's guest. A federal apex court issuing a public statement to defend the independence of one of its sitting justices in the middle of a live crisis it is adjudicating is not a routine administrative clarification. It is an institution signaling that it is aware of how the appearance of proximity is being read. And that institution is precisely the one Wike must now approach to rescue his 2027 structure. Before the close, a specific data point that complicates the straightforward narrative. The May 29 Court of Appeal ruling is interlocutory, not a final determination on the merits. The matter has been sent back to the Rivers State High Court for full trial. The Okocha-led structure has maintained, not without legal basis, that the substantive Congress case, suit number PHC/3805/2024, was separately dismissed on March 23, 2026. If that dismissal holds, the interlocutory ruling of May 29 preserves a status quo in a case that no longer exists, rendering its practical effect moot. This is not a frivolous argument.
two parallel tracks in the same court system are producing outcomes that cannot both be correct simultaneously, and Wike is exploiting that contradiction as procedural cover. Most Nigerians watching this story believe the central question is whether Wike's candidates will appear on the final ballot. That is not the right question. Ballot appearance is visible and temporary. The actual question is whether the institutional infrastructure that allows Wike to exercise influence after the ballot, controlling the party machinery, directing the assembly majority, shaping Rivers' fiscal relationship with the federal government, survives the legal attrition that is currently dismantling it. Candidates can be repackaged. Structural control of a state's political economy is harder to reconstruct once it has been judicially stripped. Here is the binary verdict this evidence forces. Either the March 23rd dismissal of the substantive Congress suit insulates the Okocha-era candidates and Wike's July INEC gamble pays off, or the May 29 Court of Appeal ruling is the opening move in a judicial sequence the Supreme Court must ultimately resolve, and Wike's candidates reach the 2027 ballot carrying a legal cloud that could void their victories not before the election but after it. Which version do you believe, and what is your reasoning? Tell me in the comments. And if the depth of this analysis is what Nigerian political coverage should look like, the like is not for this channel. It is your signal to the algorithm that Nigerians are demanding this standard of scrutiny on their own politics. 3 moves. These are the most likely next steps, grounded in established patterns and current constraints. First, Wike will file an emergency application at the Supreme Court before INEC's July candidate finalization deadline. His legal team has already stated they are studying the judgment. Given the pace at which emergency applications moved through the Supreme Court during the Rivers State crisis of early 2025, weeks, not months, an expedited application is not speculative. It is the only move available that preserves his candidate architecture. Second, the Rainbow Coalition's multi-party redundancy will be activated regardless of the legal outcome. If APC candidates are formally invalidated, the same political interests will be repositioned under PDP, Labour Party, or Action Alliance to whatever extent INEC's consolidation deadlines allow. Wike built the 4-party structure precisely for a scenario like this one. Third, Tinubu's posture will be the decisive variable that determines whether either of the first 2 moves succeeds. The presidency intervened in January 2026 to halt the 3rd impeachment attempt against Fubara, a signal that Fubara is no longer expendable. Watch for federal appointments connected to Rivers State in the weeks after INEC's July list. NDDC board composition, federal project allocations, ministry positions. Those appointments will tell you whether the Abuja-Wike arrangement is being maintained or quietly renegotiated. 3 specific signals to track before July. First, whether an emergency application appears on the Supreme Court docket from the APC or the Okocha faction. Second, whether INEC's official gazette retains Okocha-era candidates without amendment. That retention, if it happens, means Wike has won the procedural battle even after losing the appellate one. Third, if the Beke faction files a motion compelling INEC to act on the May 29 ruling before the publication date. If that motion is filed, the contest moves from the courts into INEC's administrative process, and INEC's response to that motion will reveal exactly how much executive pressure has been applied to its independence.
Now, the question that opened this investigation, answered in full. Justice Emmanuel Agim authored the 3-2 Supreme Court ruling that became Wike's most powerful legal weapon in 2025. He was then photographed beside Wike at a public ceremony while that ruling's consequences, the emergency rule, the suspension of Fubara, were still in active legal contest. The Supreme Court issued a public denial. That denial was not a routine clarification. It was an institution performing its independence under conditions that had already raised questions about whether that independence was intact.
Wike must now return to that same institution and ask it to rule in his favor again on a question of party structures and candidate validity, weeks before a general election. Whether the court can credibly adjudicate that application, given the public record of what preceded it, is not a legal question. It is a question about institutional legitimacy. And in Nigeria, institutional legitimacy is not granted by the Constitution, it is earned by performance and lost by proximity. If Wike's candidates survive INEC's July list and reach the 2027 ballot through Supreme Court intervention, administrative inertia, or Rainbow Coalition redundancy, Rivers State enters the next cycle with a governor accountable to a minister rather than to an electorate. The NDDC continues to function as a federal patronage engine rather than a development institution. Oil-producing communities continue to watch their allocations pass through political structures they did not elect and cannot remove. The specific institutional consequence is this: Nigeria's most visible current test of whether a federal system can hold state governance accountable to state citizens rather than to former governors who relocated to Abuja will have been answered in the negative. Not because Wike is uniquely powerful, because every structure that should have contained him, party discipline, judicial independence, executive neutrality, was available to him as an instrument rather than a constraint. That is the systemic pattern. The Rivers crisis is the occasion for naming it. One question for the comments. If the Supreme Court rules in Wike's favor and restores the Okocha-era candidates before the July INEC deadline, does that settle the Rivers question, or does it simply move the crisis to the post-election period? What you now know, most Nigerians watching tonight's news do not have. They will see the primary story. They will see the faction story. They will not see the judicial infrastructure story underneath it, the one that determines not who is on the ballot, but who controls Rivers State, regardless of what the ballot says. If you know someone trying to understand what is actually happening in Rivers ahead of 2027, not the personality conflict, but the structural mechanics, get this analysis to them. Not for this channel, for them. The next investigation pulls on the one thread this video has deliberately left open, the NDDC, and the specific financial mechanism that connects federal allocations to Rivers State's political architecture, regardless of who wins the governorship. That mechanism has a name attached to it. We will get to it. Naija Unmasked. The mask comes off. I will see you in the next one.